Hello friends, in the series on the income tax cases, today we will discuss a very important case on the limitation period for imposing the penalties by the authorities. If we see section 275 subsection 1 clause C, which talks about the limitation period for imposing the penalty, that section talks about the limitation period for imposing the penalty from the date of initiation of penalty proceedings. So the whole dispute arises on the focal point that when the initiation of penalty proceedings should be deemed as started, whether it should be the date when the AO marked to his superior for penalty or the date when his superior issues the show cause notice to the assessee. This issue has been taken up by the Honorable Delhi High Court in the case of Commissioner of Income Tax TDS versus Turner Journal Entertainment Networks India Private Limited, and this case is reported in 479 Ι.Τ.Α at page number 263. The date of the judgment is 6th November 2024. The present case relates to the assessment year 11-12. The assessee has filed a loss return, and in the tax audit report for the concerned assessment year, it was specifically mentioned by the tax auditor that there was some instances where the assessee has not deposited the TDS. There is section 271C which talks about penalty for failure to deduct TDS. So when the assessment was completed by the assessing officer under section 143 subsection 3, then after completing the assessment, the assessing officer marked this matter to the Joint Commissioner for penalty purposes. And when this matter was marked to the Joint Commissioner, the Joint Commissioner did not take any step to further impose the penalty on the assessee, but near about a year after, when this reference was made to the Joint Commissioner, he issued the show cause notice that why the penalty for failure to deduct the TDS should not be levied on the assessee. The assessee, apart from his submissions, said that this penalty is time barred because it is not in the year in which the proceedings have been completed, or it is not in the within the period of 6 months when the order of the CIT appeal or the tribunal is received. So these proceedings are time barred. But the Joint Commissioner went ahead with imposing the penalty. When this matter was before the CIT appeal was convinced with the assessee that in the present case, the date of initiation of penalty proceeding should be taken that date on which the assessing officer has marked the penalty to the Joint Commissioner. Since in the present case, the Joint Commissioner has issued the show cause notice near about after a year from that reference, so this penalty is clearly time barred. When the revenue took this matter to the tribunal also upheld the order of the CIT appeal, and when this matter was before the Honorable Delhi High Court, the Delhi High Court said that the concept of initiation of penalty proceedings cannot be delayed arbitrarily. The court was of the view that the expression action for imposition of penalty initiates when a reference is made by the AO to the Joint Commissioner, and reference by the AO is marked the first step in imposing the penalty. So when the assessing officer marked this application to the Joint Commissioner, since the Joint Commissioner did not take any actions for 1 year, so in the present facts and circumstances, according to the time limits given in section 275 subsection 1 clause C, the penalty imposed by the Commissioner is clearly time barred. Friends, on the same issue more or less, the Honorable Delhi High Court has given 2-3 more judgments on the same issue. So more or less the concept is the same, the ratio is the same. So these cases are very important as far as the limitation period for imposing the penalty or for passing the penalty orders are concerned. At the end of this video, once again, I am repeating the name of the case. The name of the case is Commissioner of Income Tax TDS versus Turner Journal Entertainment Networks India Private Limited, and this case is reported in 479 ITR at page number 263, and the date of the judgment is 6th November 2024. Thank you, friends.